could your organization exist in the United States, given what your mission is?
Oh, that's a fascinating. I feel like we've already started the podcast. I mean, well, we'll include this bit on there because it's a really interesting question. I do have friends in the States, and I think the answer they often say would be yes, but would it actually get any support? You know, I could start up the website.
Oh, sure you could.
Yeah, you could do everything like that, but you'd never. It would be so tricky, I think, because in the UK, you know, if you make the arguments about Norway especially, then they aren't actually that far away. So you can kind of make that argument. You can say, well, actually, no, we are similar to them. We are actually quite close to them. You know, if you want to, you can get on a plane and easily go over to Norway and see what their justice system is like. Or speak to people who've been involved in the justice system in the UK. And I think it makes it a lot more real compared to if you're, say, in the United States and you're trying to say, you know, we should have this big reform, and where are we basing it off of? Somewhere all the way over in Europe, which is you know, in comparison to the United States, you know, Norway is absolutely tiny. I mean, you have to go down to the state level. I think it'd be incredibly difficult to make it. Kudos to anyone who does try and make that argument, but it's incredibly difficult, I would say.
Yeah. All right. Well, anyway, we can get started.
But so first of all, thank you, David Rudolf, for coming on the conversation. And you were the defense lawyer for Michael Peterson. You appeared in the Netflix series, The Staircase. You were portrayed in the HBO series very recently of the same name. You even started your own law firm. So thank you so much for coming on.
It's my pleasure.
So one of the things I wanted to start with was actually about uncertainty in legal cases. Because if there's anything I think that keeps the whole case with Michael and Kathleen Peterson coming back, it's this idea that even watching the series, you never know what quite is going to happen next. You know, whether it's the blow poke, whether it's, you know, afterwards was the owl theory that came out, you know, this idea that an owl attacked Kathleen outside the house and then she fell down the stairs indoors, and any of those kind of things. So how do you think that the justice system should deal with doubt? And also, how do you think that, you know, why do you think it's important that we don't lock up innocent people simply because if we do, then, you know, you can say, I think one of the examples you gave was you could lock up sort of 100 guilty people. But, you know, if you lock up that one person, then the fundamental idea of justice can be lost.
Yeah, well, a couple of things. First of all, you know, if you lock up an innocent person, then the actual perpetrator remains free to commit other crimes. So although it's sometimes is portrayed as a liberal versus conservative dichotomy on the importance of avoiding wrongful convictions, the reality is that everybody should be aiming to avoid wrongful convictions, maybe for different reasons. But it's not good for your law and order crowd to convict an innocent person and let the guilty person go free. And it's not good for the victims of crime to have an innocent person convicted and have the guilty person go free. And it's certainly not in the interests of the defendant or his family or her family to have that. So everybody should be on the same page about avoiding wrongful convictions. That's number one. Number two, in terms of the role of doubt, you know, I think actually Scotland has it right. You know, Scotland has 3 verdicts: guilty, not guilty, and not proven. And I think that every country should have 2 verdicts: proven or not proven. I don't think any country ought to be limited to this binary guilt or innocence, or not guilty, guilty. Because when a jury says not guilty, there's sort of an implicit conclusion that the person is innocent. But that's not what the verdict is really saying. The verdict is saying not proven. You didn't prove it beyond a reasonable doubt. Now, you know, we could have debates about whether beyond a reasonable doubt is the right standard. I happen to think it is. You know, other people might think it should be, greater weight of the evidence or something in between those two, clear and convincing. But once you settle on what the standard should be, then it seems to me it should either be that standard has been proven for the jury or the standard has not been proven for the jury. I think that would make the system much more transparent to everybody. Because when a jury comes back and says, not proven, it's pretty clear that what they're saying is you just came up short. We're not saying this person is innocent. We're just saying you didn't meet your standard of proof, your burden of proof. So that's why I think, doubt and uncertainty is really important in the criminal justice system to avoid letting actual perpetrators go free and convicting innocent people.
So my next question actually was going to be about the not proven sort of verdict that they have in Scotland. So what do you think though about them having, in their case, they have sort of guilty, not guilty, and not proven all at the same time? So at the moment there is they're actually doing a consultation, the Scottish government, and it's interestingly seems to have been spurred in quite large part by Alex Salmond. So he was the former First Minister. And it's a lot to do with, in their case, with sort of sexual assault cases where it'll end up being the verdict will be not proven rather than either guilty or not guilty. So what do you think about their system of, firstly of reviewing it, but also of having free whole verdicts all at once?
I don't really understand the purpose of the three verdicts. I mean, I could understand it if you had a verdict that said innocent, where a jury was going to actually affirmatively decide that someone was innocent. Although, you ought not have to prove that to escape from the consequences of the criminal justice system. So I don't really understand the rationale. I think what happened was, if my memory serves me correctly, because when I was over there, I was interested in this. I think what happened was they originally had the guilty, not guilty, and then the not proven was added at some point later on. And I'm not quite sure what the impetus was of that. And when I was over there in 2018, there was a fairly infamous case, a sexual assault, where the person was found not proven. But then there was a civil proceeding where the person was held responsible. And so there was an uproar, by the victim and the victim's supporters about, well, why wasn't he found guilty if, he was found responsible on the civil side? And I think that's sort of what led to a re-examination. But for me, that was faulty logic. I mean, there's a different burden of proof. So it makes perfect sense to me that somebody could be found responsible by a greater weight of the evidence, which is the standard for civil liability, but found not proven by beyond a reasonable doubt. I don't see any conflict between those two. And I think that was sort of the gravamen of the complaint, was that somehow those verdicts were inconsistent with each other. And I don't think that's true. So my hope is that they're not actually thinking about changing not proven. I would prefer them to change the entire thing to proven or not proven. I think that would make infinitely more sense. Basically, that's the question. Has the prosecution proven their case beyond a reasonable doubt? Either they've proven it or they haven't proven it.
Well, I think you've just come up with a good new policy proposal there.
Well, good. Why don't you push that?
I was going to say it's a very good one, actually. So just to move on, in some ways, to looking at the trial itself, one of the big things was cameras being allowed into the courtroom in the Michael Peterson case, and in some ways, the documentary, as we now know it, wouldn't really exist without the cameras having been in the courtroom. Whilst in the UK, it's a very different situation. I mean, we actually have courtroom sketch artists specifically for the fact that you aren't always actually allowed in court, even when sort of verdicts are being read. So do you think that overall that move towards cameras being in courtrooms was a positive case, a sort of positive step, sorry, or was it actually something that risks creating that sort of media circus? I mean, we saw with the Amber Heard Johnny Depp trial recently.
I'm actually not particularly in favor of cameras in the courtroom. Now, let me just say this. If what you're going to do is what court TV in the United States set out to do 20 years ago or 30 years ago, where they were going to cover trials gavel to gavel, people could tune in anytime to watch as much of it as they wanted or as little of it as they wanted. I could see there being some benefit in terms of just educating the public about how the system works. Mm-hmm. So that, I think, would have some marginal usefulness in much the same way that I think The Staircase educated the public in ways that no other documentary really has about how the system actually works in real life. So that has some value. Does it have any value to allow cameras in the courtroom so that on the evening news you can play a 2-minute or a 90-second clip of a particularly dramatic moment? I don't think that does anything to educate the public or to really give them any real insight into the case at all. It's a moment in time. It's like a snapshot. So I do think that having cameras in the courtroom, to the extent it leads to those kinds of snapshots, on TV at night or in social media, is a negative because people think they're getting the actual taste of what's going on, but they're not. When it's a reporter who's in the courtroom all day long and is listening to both sides and assuming that the reporter is conscientious and fair and can summarize a full day's testimony, but then there's some value to that. You get a much better feel, but not for the 90-second clip. I just don't think that serves any purpose. On the other hand, I will say that I don't think having a camera in the courtroom really affects any of the participants. It may affect the jury because they know that other people are watching, and that may make them either more conscientious or more skeptical or something. But I don't think it really affects the lawyers, and I don't think it really affects the judge, and I don't think it really affects the witnesses. I think the Amber Heard Johnny Depp trial would have been a farce without the cameras there. It just seemed to me to be everybody was sort of taking a role there. I'm not talking about the lawyers. I'm talking about the witnesses and the parties. Everybody was playing a role. And maybe that was inevitable given the fact that they're all Hollywood actors. I didn't feel that about the lawyers particularly. But I think that would have been the same whether there were cameras there or not.
So do you think in your own almost part, I would say, in the Netflix series on The Staircase, do you think that you sort of helped to change the image of defense lawyers as well? And was that sort of one of the positives that maybe came out of it?
That was actually my goal. When I agreed to do it, I had, Michael had his own goals, which were different than mine. But my goal was that I was sick and tired of how criminal defense lawyers were being portrayed in the popular media, whether it was on TV, in shows like Law and Order, whether it was in movies. We were always portrayed as sort of unethical, trying to trick the judge or the prosecutor or the jury, not really caring about our clients. There was just a whole series of stereotypes that had grown up over the last 30 years, which I had not been subjected to when I was growing up, because when I was growing up, it was Perry Mason, who was a good guy. He was looking for the truth, and he was clearing people of crimes that they didn't commit. So that was my goal, was, okay, let's show people what we really do, both in preparing for trial and in the courtroom itself. And so I'm gonna open the kimono, so to speak, and let everybody see. And that's what we did. There were no second takes. There were no, gee, can you do that again, David? There was none of that. It was just, they filmed what was going on. And I have had probably hundreds, if not more, maybe thousands of people texting me or leaving comments on my website, basically saying to the effect of, whether Michael Peterson is guilty or innocent, some think he's guilty, some think he's innocent. Regardless of that, you made me understand a lot better what criminal defense lawyers do. I have a whole new appreciation of what your role is in the system. And so I got lots and lots of positive feedback about the role of criminal defense lawyers. And I know from talking with other criminal defense lawyers in the United States that they have felt that as well, that the staircase did improve our standing, if you will, with the general public. And so that's what I'm probably most proud of about the staircase, and most grateful for.
Norwegian prison system, of course, is, I would say, a world away from either the US or the UK prison systems at the moment. Why do you think there's such a resistance to moving towards that system? After all, the US system seems to be more and more about punishment and deterrent. Norway's system is more and more about, rehabilitation, and ensuring that prisoners actually learn skills in prison that they can, fit into society afterwards, reducing reoffending rates. Why do you think it's such a difficult sell in the US and the UK right now?
Well, I can't necessarily speak to the UK. In the US, I just think there's this sort of, Protestant sort of ethic that, sort of an eye for an eye idea. And so there's a certain desire for revenge or retribution or punishment, that I think is somehow wrapped up in religion in some way. And I'm not quite sure how, but it just says, the whole concept of heaven and hell and good and evil. It just seems to me that there's a religious-based judgmentalism and desire to punish when somebody does something wrong, as opposed to a desire to understand and to, as you put it, rehabilitate and leave people in a better position when they come out than they were when they went in, all of which is completely rational. And it eliminates that whole notion of, we need to get our pound of flesh from this person, because that's really what it's about at the end of the day. It's, we need to get our pound of flesh. This person did this, and so he needs or she needs to pay for doing that. And I get that to a certain extent. I mean, there has to be deterrence, and deterrence is fine. But, when I was going to law school, we often talked about the fact that, the goals of punishment could be deterrence, they could be retribution, or they could be rehabilitation. And back in the day, in the 70s, rehabilitation was something that people actually in the United States considered as a goal of incarceration. That long ago died away, long ago. As crime increased, as the drug problems increased, as people got more and more scared about crime, we became much more revengeful, I guess, would be the right word. So, in my mind, it's not a rational reaction. I think the reaction in Norway is much more rational, much more productive in terms of the overall health of the society. And I think you see that in, the crime rates and the rates of recidivism. So, the proof of the pudding is in the eating, isn't it?
So it kind of leads on to my next question, which is then, if you were going to try and convince people in America of sort of a Norway-style system, would there be a place to start? I was going to say, where would you start to try and do it? Or do you think it's just almost too far gone now that it's, it would be almost impossible to say, actually, let's focus on rehabilitation? Or do you think it'd be such a tough argument that?
Torrin, the atmosphere in the United States right now is that we can't even agree that assault weapons ought not be easily available to 18 to 21-year-old, to anyone really. I mean, what's the purpose of an assault weapon other than to kill as many people as you can, as quickly as you can? So we can't agree on that. We're certainly not going to even begin a conversation about the value of rehabilitation. We ought to begin rehabilitation with rehabilitation of certain members of Congress who need to be rehabilitated about their values.
Mm-hmm. An interesting start. So I will say my final question, and again, it's sort of on a slightly different subject. But one of the things that you've said in the past is that you wanted to encourage at the time, new law students to represent poorer people. And one of the debates in the UK has been around legal aid, which goes to people who can't afford to pay their own legal costs. So really, I just wanted to ask why you think it's such an important part of the justice system to ensure that those people are represented and sort of have a fair trial in comparison to, what would simply be not allowing them as good a representation, or if any.
Well, and I know that's a big issue right now because as I have read, I think your barristers are on strike. Yeah. Over pay and working conditions, which is a pretty dramatic development, I think, and it speaks to the very issue you're talking about right now. The reality is that in order to have a fair trial, a really fair, I mean, if you were gonna not have prosecutors, if you were going to have the victim be the prosecutor or the victim's family or some person appointed by the victim, not a lawyer, but some lay person appointed by the victim to try the case for the prosecution, well, then maybe you could do the same thing on the defense side and it would be, a fair fight, if you will. But you can't have the Crown on one side of the courtroom and somebody with a, sixth grade education, completely untrained, unknowing of the rules of evidence or the rules of procedure, be able to mount a fair defense. And the problem with that is if you can't mount a defense, you're inviting error. You're inviting convictions that ought not occur. And then the question becomes, what's the cost of that to a society? In the United States now, as you may know, I have basically devoted my career in the last 10 or 15 years to suing police officers and other individuals, law enforcement individuals, who are responsible for wrongful convictions, to secure monetary compensation, because that's the best we can do for the victims of that. And, you know, in a place like Chicago, where this was a rampant problem, the city of Chicago has paid out hundreds of millions of dollars in damages to people who were wrongfully convicted. Imagine if they had instead devoted those resources to public defenders, and not just what they're paying the public defenders, but to caseloads and managing caseloads, and to providing the kinds of ancillary services like experts to help them represent people. I'm not sure it wouldn't have been a cost savings to have done that. So, you know, I think it's short-sighted to not have public defenders. I think it's very short-sighted to not fund those people properly, not to pay them, you know, what you're paying prosecutors, and to not give them the resources and the time to do their job. You know, you don't want to have prosecutors who are so overworked that they can't properly present their case. And you don't want to have defense lawyers who are so overworked that they can't properly defend their clients.
Well, thank you so much for coming on the conversation. It's been fantastic to talk to you, David.